fast. So in Companies Act, what we are going to do here, this Companies Act you already have or not?
No, sir.
Okay. So today I'll send it to everyone. Okay. And don't take a printout till I tell you, because I will keep on adding the lots of value in that. So just use it for the reference. Don't take a printout. So today we will be starting from this topic, the most important topic, that is about the appointment of directors. So chapter number 11 of the Companies Act. It is appointment and qualification of directors. Section 149 to 172. The next is chapter 12, meetings of the board and its powers, section 173 to 195. And the next chapter number 13, appointment and remuneration of managerial personnel, 196 to 205, read with schedule number 5. Now, these 3 chapters will constitute not less than 30% of your paper. Is there anyone here who has attempted earlier?
Yes, sir.
So how much percentage of these chapters are there in the exam?
About 30 to 40%.
30 to 40%, and that is the reason I have taken this in the beginning, so that any number of questions you have on this chapter, not now, not during the lecture, afterwards also, till your exam, keep on asking me. And we'll spend good time on these 3 chapters. Quite possible these 3 chapters means 10 lectures, possible. Okay, but we will do each and everything in minute detail, as much detail possible. We will go into that, because not only for the purpose of exam, even after the exam also, as a professional, most of the questions which you are going to face in a career, as an expert in company law, majority of the questions are going to be related to directors, right? Now, our friend is asking whether recording will be available. Yes, recording of every lecture will be on my website. You can view that any number of times, and that will be up till 15th of January. Okay, there is not one-time lecture. I'm giving you so many options. So by chance, if you happen to miss, by chance there is a network problem, by chance there is not a clear understanding, go to the video, take a note that on which day we have delivered what, right? So that should be in your diary, because on the website it will be in a sequence: lecture 1, lecture 2, lecture 3, lecture 4. Contents will not be there. So you will have to identify which one you are looking for. So always keep a note, or rather keep the first page of your diary or the notebook for this purpose, that what we are covering today. Lecture number 1, dated 22nd of July, coverages from this to this. The next day, that way keep it track. So it will be easier for you to follow in the recording. Is that good enough?
Yes, sir.
Fantastic. Okay. So these 3 chapters are crucial, and if you are a master of these 3 chapters, not only you will pass the exam very easily, as a professional, as an expert in company law, you will have a different value. Okay, so this is what we are going to cover up. I said in these 3 chapters, quite possible we end up taking 10 lectures, possibly 10, maybe less, maybe more. Let me assure you, I'm not in a hurry to complete the syllabus, nor you should be. Objective is you are here for the purpose of learning, and my objective is to ensure that everybody learns. Perfect?
Yes, sir.
I want everybody to learn thoroughly, and company law should not be a problem at all for the lifetime. We are here learning for the lifetime. So now I'm going to the Companies Act. Here comes the Companies Act. as usual, I have downloaded the sections, how to access website. I'll give you the passwords. I'll send it tomorrow because it takes 1 day to upload. So everybody will get individual IDs and passwords. For that, what you need to do is that today itself, all of you will send me your email IDs. I will get it created for you. And tomorrow when it is uploaded, access will be given to everyone. Okay? You can log in with your ID and password and ensure that it is your personal property so it is not shared with anyone. So in the beginning, I have section 1 and section 2. So as usual, this is section 1. Section 2, we keep coming again and again. That's why it is here. And in section 2, we have 95% plus definitions. Earlier, these are 95 definitions, right? Now, there are two types of definitions which are given in the beginning, which are under section 2. And there are certain definitions which are given in a specific section, right? Do you remember any such definition?
Books of account.
Books of account, that is in section 2. Any definition which is given in a specific section.
Key managerial personnel.
Key managerial personnel, right? So where it is defined?
Section 203, I think.
Section 203, okay? So when it is defined in a specific section, what does it mean? Why it is not given in section 2?
So I think section 2, subsection 51.
That is what I am doing. Okay, so this is already defined here. So when something is defined in a section, it is not under section 2, it means that definition is relevant for that section only unless it is given otherwise. And when it is given in section 2, that is applicable for the entire act. Is this clear? Definitions given under section 2 or rather in the beginning of the act, those are applicable to the entire act. And the definition given in a specific section, that is relevant for that section only. Okay? Now I'll take you to a specific thing. I'll give you an example. Let us go to page number 30. I'll show you that. See here, section 151. What does it say?
Small shareholder.
Every listed company may have a director elected by such small shareholders. Now, who's a small shareholder? Now, see here. Read this carefully. What it says? For the purpose of this section, it is not saying for the purpose of this act. What it said is, for the purpose of this section, a small shareholder, just a minute, we have two friends who are a little late. Nikunj Thakkar. Nikunj, your name. Let me see. Okay, I must have sent it to you. And who is this admin? Whose name is this admin? Just let me ask this person. Whose name is admin here? Just recently logged in. Who's this gentleman? By the name admin? Anyway, you need to identify. Anyway, so now section 151, again, we will see this in the explanation. What does it say? Okay, so this says for the purpose of this section, right? While in section 2, whatever we talk about, that says for the purpose of this act. That is the difference of definitions given under section 2 and under different sections. Okay? And I wish you to keep the mics on mute, and when you have to speak something, always unmute. You can keep your cameras on, so that will help me to understand whether it is clear to you or not. Cameras are on and mics on mute. Good enough? Mr. Prabhu, good morning. So,
Good morning, sir.
good morning. So, is that point clear? Janavi is coming. Yes, Janavi is welcome. So got little late. So starting from section 149, this is appointment and qualification of directors. And the title says, company to have a board of directors, right? And if I add one word here, it will make it more meaningful. This is. Okay, Nikunj, once in a while it may happen. Okay. And somebody's name is being shown as admin. Just check whose name is. So every company to have board of directors, right? Now, what is the meaning of board of directors? For that, again, we go back to section 2. Okay. So on when I go to section 2, what it says, what is the meaning of board of directors? Poonam is coming now. Yes, Poonam is loud. This is the definition of the term board of directors. Section 2, subsection 10. Section 2, subsection 10, this is defining board of directors means what? So this simply saying that board of directors or board is in relation to a company, means collective body of the directors of the company. So board of directors is name given to body of the individuals, collective body of directors of the company, that will be called as board of directors. Right. Now let me clear itself that only an individual can be a director. So this is my comment I am adding here. So that's why I said that don't take a printout when I send it to you. And when it is final, then you can take a printout, because we'll keep on adding the comments here. Okay. So ultimately, what is the board of directors? Board of directors becomes a body of individuals, and that is in relation to company. Right. Now here I said only an individual can be a director, and let me add further, and individual can become a director only in accordance with the provisions of this act. So when we say board of directors, means it's a collective body of directors. Who are directors? Only individuals can be directors. No person other than individual. You see, some time back there was a discussion on the group whether HUF can be the subscriber to the memorandum. HUF is not a person for the purpose of law, and certainly it is not an individual. Right. So HUF can subscribe to the memorandum, but only through Karta. right? So ultimately, it is the responsibility that comes on Karta. So if the HUF happen to be a signatory through the Karta, then who can be director, whether HUF or the Karta? It is only the Karta who can become a director, because only an individual can be a director, and individual can become a director only in accordance with the provisions of this act. There is no way a person can become a director otherwise. Only as per procedure of law given in this act, an individual can become a director, right? So right now we have just defined what is the meaning of board of directors. Now let's see further. Here comes director. So earlier we have mentioned the director only an individual appointed in accordance with the provisions of this act. So here comes section 2 subsection 34. This is defining director means a director appointed to the board of a company. Who appoints?
By board.
No.
By board.
No, there are multiple ways of appointment. First, directors are appointed by giving their name in the articles or otherwise. Subsequent directors can be appointed either by the board or by the general meeting. Then there are outsiders can also nominate. They are called as nominee directors. Government can also appoint directors. So there are different bodies who can make an appointment, right? So they are appointed as per Companies Act, not only by the board, right? Only for your reference, first directors are generally appointed by the name being given in the articles of association. Subsequent directors are generally appointed in the general meeting, but additional directors can be appointed by the board. Alternate directors can be appointed by the board. Casual vacancy can be filled up by the board. Financial institutions can appoint the nominee directors. Government can appoint the directors on the company's board. They are called government directors, right? So there are multiple ways how the directors are appointed. So it is not only the board. There are multiple ways. So here we'll simply say means a director appointed to the board of company. How? As per provisions of this act. Is that clear?
Yes, sir.
Yes, sir.
Okay. There are multiple ways how the directors are appointed. Okay. So now we are going back to the same page where we were, and we were on page number 27. So here we go to page 27. And there we close. So the title of the section, this says every company to have board of directors. So when we say every company, whether this is private or this is public, it is a government company or whatever it may be, doesn't make a difference. Provisions are equally applicable to all companies. Now my question here is whether foreign company is also a company or not for the purpose of this act. Foreign company is a company or not a company for the purpose of this act? Monica says yes. Foreign company is a company?
Yes.
Yes.
It's not a company as per the provisions of the Companies Act because it is not registered in India.
Correct, correct. Okay, fantastic. Now let me give explanation to everyone. See, what I'm encouraging everyone to be very, very clear about every word of law, right? So initially it will take you a little time to catch hold. Now I'm taking you again to section 2. Let's go there. Write the definition of the word company. Section 2, subsection 20, that is defining the term company means a company incorporated under this act or under any previous company law. Foreign company is not created under this act. Anusha, getting it clear?
Yes.
So company, the word company does not include a foreign company. Why it does not include? Reason is there in the definition. This says company means a company incorporated under this act or under any previous company law. Okay, and foreign company is not incorporated under company law in India. Is this point clear?
Yeah, yes.
Okay. Now I'll take you to another definition to further give you more explanation about this. Read this definition, body corporate. Body corporate corporation includes a company incorporated outside India.
Body corporate does not include.
So company incorporated outside India will be referred as a body corporate, not as a company under this act. Is it clear?
Yes, sir.
Okay. A
So,
body corporate includes a foreign company, but company means only a company which is incorporated under Companies Act in India. Okay. So Companies Act in India. So now we have Companies Act 2013. Prior to that, there was Companies Act 1956. Prior to that, there was Companies Act 1913. Exactly 100 years back, before 2013. Okay. And prior to that, there was Companies Act 1888. So whether company is created under the Companies Act 1888 or it is 1913 or 1956 or 2013 doesn't make a difference. Every such entity which is incorporated under the Companies Act in India, that will be referred as a company, and if it is incorporated outside India, it will be referred as a body corporate. Right? But it does not include,
under this company.
body corporate does not include a cooperative society. So what does it mean? A cooperative society is not treated as a body corporate. A cooperative society is not an individual. So cooperative society cannot become member of a company. Right? Cooperative society is not a body corporate, not an individual, so it cannot become a member. Then any other body corporate which is the central government may by notification specify in this. So this is inclusive definition. Now my question is whether body corporate includes a company or not.
So it includes company because it includes, it's an inclusive definition. So certainly even companies will be part of body corporate.
Okay, now you can write a single line definition for the body corporate. Okay, I'm giving you a single line definition for the term body corporate. And for that, let me go to another share. We'll come back here. Body corporate means a legal entity created under any law anywhere in the world. Body corporate means a legal entity created under any law anywhere in the world. Right? Now, world includes India and law includes Companies Act in India. Therefore, every company under the Companies Act is also a body corporate. But every body corporate is not a company under the Companies Act. Noted?
Noted.
Cooperative society is a legal entity, but not for the purpose of Companies Act. To read Cooperative Societies Act, that says it is a body corporate, but not for the purpose of company. Okay. I hope Artika, you got the answer. Good. When a promoter becomes a subscriber, is it the question, Sangeeta?
Yeah, it was. It's mistakenly sent. Can a promoter become subscriber and also a director of the company? Because
Yes.
one man are more
Always,
like
always. Actually,
always.
actually the promoters are only the first subscribers to the member. They are the first directors generally. Okay.
So then it will become means decision will become depends on one person only, right?
Mostly. So local authority is also body corporate, right? Yes, local authority is also body corporate. It is created as a separate law. So is this done? So now we are again going back to the Companies Act. So this is what we were talking about. So for reading one line, how many places we need to go and refer? That section simply said that every company. So what is the meaning of the term company? Only for understanding that we went here and there. But this is a clarity done only required only once, and now thereafter there will not be any more confusion. Is this clear?
Yes, sir.
The first line says every company. So company means which is incorporated under any of the company laws or Companies Act in India shall have a board of directors. Board of directors means it's a body of individuals, right? And it further says consisting of individuals as directors. So means any body corporate cannot become a director. HUF cannot become director. Partnership firm cannot become director. Only an individual is allowed to be a director. Right? Why only individual? Question is why only individual? Tell me. Why only individual can be a director?
Because company is acting through the company is acting through these individuals who are like agents.
Company is acting through the individual. Okay. Poonam says they can take decisions. Okay.
When the company is having legal existence,
Now Nikunj has given the correct answer to fix the accountability. Ultimately, there is a responsibility to comply with the provisions of law, and it is the responsibility of the directors to comply with all the provisions because there is an intention involved. And who can have intention? Only a natural person can have intention, isn't it? So whose mic is this creating a lot of disturbance? Please check whose mic is this. So the first line again, every company shall have a board of directors consisting of individuals. So every word is clear. Company, board of directors, individual. Okay. So individual, again there are section 164 that is talking about disqualification. So every individual cannot be a director. We can add further. You see here I am adding my comments. Not disqualified under section 164. Now it makes more sense. Because prima facie it is saying every individual can be a director, but not every individual, there are disqualifications. It is also subject to number of companies in which he is already a director. So individual can become a director provided he is not disqualified under section 164 and he is not holding the number of directorship which are beyond the limit prescribed under this. So individual but subject to two things. Number one, he is not disqualified, and number two, he is not a director in the number of companies which are a restriction or which is a limitation herein. So according to this act, an individual can be director in 15 companies. So when he is already in so many number of companies, thereafter he cannot be appointed as a director anymore. Is that clear? Now, minimum number of directors and maximum number of directors. Minimum number of directors, that is one company, 1, 2, 3, that is a one-person company, then private company, then public company, that is minimum. Now, what is the meaning of minimum? That if the number of directors is below minimum, the constitution of the board of directors will become invalid. The individuals will continue to be directors. Say suppose in a public company there are 3 directors, and out of 3, 1 director either resigns or he gets disqualified or he dies. Only 2 are remaining. The question is whether remaining directors can be referred as board of directors or not. Understand this practical situation. There are 3 directors in a public company. Out of 3, 1 director is either disqualified or he resigns or he dies. What will happen to the remaining 2 directors, whether they are directors or not?
Yes, sir, they are directors.
They are directors, but whether they are board of directors or not?
Yes, they are.
No.
As per this provision, they cannot be because minimum number is come down.
Yes. So when the number of directors go below minimum, those individuals will be called as the directors, but they will not be treated as a board of directors. So to consider a body of individuals as a board of directors, minimum number of directors should always be there. Okay. Now, when the 2 directors are remaining, what they can do in a public company out of 3, if 2 are remaining, then what will happen? Those 2 directors cannot act as a board. They can only call either board meeting or general meeting for increasing the number of directors. Nothing else. Okay. So that is also very important. That board of directors means valid board and invalid board. What is the impact of that? Okay. So let me write here. I'll write on the whiteboard. This is required, or I can clear this? If number of directors in company falls below minimum, the remaining directors are not treated as board of directors. They can not take decisions as board of directors. They can call general meeting for increasing number of directors. So if number of directors in company falls below, I can add here one more word, that is statutory minimum. So any question on this? Keep on interacting with me so that things become more interesting. Is this done?
Yes, sir.
Okay, so now we go back. See, in this process, you will learn how to read law. So when they are board of directors, how they appoint another. So a very specific right has been given under the Companies Act that when the number falls below, they can act only to appoint one more director. So to bring the number to minimum, they cannot take any other decision except appointment of the director. So a special right has been given. That right was not there under the Companies Act 1956. That is a right given in this Act, Companies Act 2013. That is the number of the directors fall below statutory minimum. The remaining directors can act to appoint more directors, so the number becomes minimum. Why? Because when the number is below minimum, it is not a board of directors. And they cannot take any decision in the capacity of board of directors. And all the powers in the Companies Act are given to the board of directors. Right? That also we can add. That is something interesting that we are writing here. Okay. So let me clear this. Under the Companies Act, all the powers are given to the board of directors. No power delegated to an individual director. All the powers are given to the board of directors. No power delegated to an individual director. Directors can act on behalf of the board of directors. So whenever directors sign, they always sign on behalf of the board. So there is no power given to any director in the individual capacity. All the directors, or rather all the powers under the Companies Act, are vested in the board of directors. Balaji is asking the question, can members appoint directors in AGM? Yes, they can. Section 152, we will go into the details of that. Okay. Rashmi, your mic is mute. I cannot hear you. Yeah, tell me.
Sir. Okay.
Noted? Fantastic.
Noted, sir. Okay.
So going back to the Companies Act. Yes, everybody I can hear, but keep your mics in control. When you have to speak, switch it on, unmute yourself, otherwise keep it on silent mode, please. Now, minimum number of directors. So I hope you got the meaning. What is the number? What is the impact of minimum? Now, maximum it says 15 directors. It is not saying whether private company or public company or listed company or unlisted company. For all companies, requirement has become common. Then maximum number of directors should be 15, and you can increase it further by passing a special resolution. So up to 15, it is already authorized by the Act. And this further says a company can appoint more than 15 directors, but after passing a special resolution. So you don't need to get the approval of central government. You don't need to go to the approval of any other authority except passing a special resolution. So when the company is growing in size, at that time itself, you can pass a resolution. And this is a one-time resolution having unlimited validity. See, this is something very important. That again, I'm giving you a note separately. Take it here on the whiteboard, right? So this I will clear. I give you so many things which are generally you can apply anywhere else. Okay, so generally there is no fixed validity period of a resolution unless so specified under the Act. Therefore, a special resolution authorizing more than 15 directors is required to be passed only once. Noted? Surinder?
Yes, sir.
Good.
So wait.
See, when lectures were being done for ICA side, there was a limited time given to us, so we were little fast. Now, the actual lecture. Till
So
you have
done.
noted, we will not go ahead. Okay?
Sir, maximum is 15 directors, right, sir?
Maximum
limit is 15, sir.
15
For
is
directors.
authorized by the Act. You can go by beyond 15 by passing a special resolution.
Sir, how many more can be appointed, sir? Is there
As
any
many as
limit?
you, as many as you wish. The more the directors, more the problem for the practice for the company secretaries. Better not to have more than 15 directors, isn't it? Because when you have more directors, then organizing board meeting becomes a real pain. Everybody is full of egos. How do you get the consent of so many people to participate on the board meeting on the same day?
Sir, Act's limit is prevail over Articles limits, sir.
Pardon?
Companies Act limits are prevail over companies Articles of Association limits. Right? My understanding is
Okay.
like that.
Okay. Now let me give you answer for your question. Okay.
Okay.
Now I'm removing this one, and your question, I think everybody has heard, whether article prevails or Companies Act prevail. That is a question. Okay. Act is authorizing maximum 15 directors. Through articles of association, you can reduce it. In this case, articles of association prevails. If you wish to have more than 15 directors, then pass a resolution and make provisions in the articles of association. Provisions for more than 15 directors in articles without passing a special resolution shall be invalid. So what your answer?
Yes, sir.
Yes, sir.
Yes. Any more question?
So I have a question.
Yes, please.
Sir, otherwise also, if some in the articles, if
Mhm.
something is against the provision, then only the provision will prevail. Otherwise, the articles will prevail over the provisions. If it's within the, if it's not invalid in any other terms.
See, wherever act is silent, you can have any provisions in the article. If you have anything contrary to law in the article, then act will prevail, right? And where permission is granted by the law that you can have provisions in the articles, and you make something which is not as per act, then articles will prevail.
Okay.
Okay.
Thank you, sir.
And here
Can
is
we
one.
take this as entrenchment section? Entrenchment of article?
No, entrenchment is entrenchment provisions are that where you prescribe in the article something much more strict than what is in the law. Law says ordinary resolution, and your articles is talking about a spatial resolution. That is entrenchment provisions, right? So what the act requires, you are going much more strict than that.
Sir, I have a question.
Yes.
Special resolution required for appointment of director as well as for amending the articles of association.
No, for appointment it is always the ordinary resolution. For amending the articles, a special resolution.
And in the ICSI classes, you said resolution is a decision.
Yes.
And before decision, it is called motion. But in most of the places, it is said resolution. Resolution is referred.
That is what the problem is. Okay, so legally, resolution cannot be passed. After passing, it becomes a resolution. But in practice, in common, it is always referred as a resolution. Let it go that way only. But when you're writing in the exam, make it sure that instead of saying a resolution proposed before the meeting, you say a proposal placed before the meeting, or a motion placed before the meeting. After the motion is approved, it becomes a resolution. Clear?
Clear, sir. Thank you.
Good morning, sir.
See,
I have a question.
yes.
So, if any provision is there in article that is more stricter than the act, and we wish to follow the act and normalize the articles, what can we do?
See, I'll give you the answer in writing. Okay? Take note here. Where articles prescribe more strict provisions than the act, requirements of the act get fulfilled automatically. That's why articles are valid. Where article prescribe more strict provisions in the act, right? Here itself we can put for example, a spatial resolution in place of ordinary resolution, right? So ordinary resolution means how many votes in favor?
50. 15.
50.
More than half. More than 50%.
Half, so 51%.
Anything more than 50%. It can be 50.01, that is also okay, but anything more than 50%. Exact 50%, there is a tie, nothing happens, right? No decision. Anything more than 50, that is required for an ordinary resolution. Just a minute, 1 minute. Hello. And for a special resolution, how many votes are required?
3 times more in favor as against.
3/4 of the present in voting.
3/4, 75%.
It is 75 or more than 75?
More than
3 times more than cast in
More
against.
than 3/4.
Not more than 3/4, no.
3/4 of the present in voting.
You see, there is a difference. In ordinary resolution, we require more than 50%. Write the words, right? I'm writing here for you. For ordinary resolution, number of votes in favor should be more than 50%. Underline the word more than. Okay. For a spatial resolution, number of votes required in favor should be 3/4 of all valid votes or more. What is the difference in the language?
Was at least
Exactly, sir. Exactly. At least.
Even exactly 3/4 will also make it a spatial resolution, but exactly 50% will not make an ordinary resolution. For ordinary resolution, we require more than 50%, and for spatial, we require 3/4 or more.
Or more.
Clear?
Yes, sir.
These are questions which can be there in the form of MCQs, in the form of fill up the blanks. These are minor and finer points of company law. Valid votes in favor. Yes, valid votes in favor. Okay.
Sir, I have a doubt.
Yes.
Shall nominee directors will also be included as maximum 15 directors?
Which one?
Nominee directors.
Yes, they are also included. Unless
With a maximum limit of 15, sir.
Unless there is a special exclusion, they will also be counted.
Okay, sir. The directors appointed by the tribunal for specific reasons.
Directors appointed by
Tribunal or government for specific reasons.
When they are appointed under a special law, then a special law always prevails over common law.
Okay, sir.
Okay. Say now there are some directors being appointed by BIFR. You know BIFR?
Board for Industrial and Financial Reconstruction.
Right. That is for the SIC company. So if a director is being appointed by BIFR, any order of BIFR prevails over every other law. In that situation, this limit will not be applicable. So in general, you understand. Okay. So here I will write another line for you. Keep a note. Take a note of this. But this is separate from the what we are writing. Any special law always prevails over general law. So company law becomes general. So if a director is being appointed under a special law, then that law will prevail, not the Companies Act. Done?
Sir, what does the
one
special
more
law
thing.
includes?
A special law. For example, SICA, Sikh Industrial Companies Act. That is a special law. Right? Say for example, Banking Regulation Act. There RBI will have overriding power over MCA. Take Insurance Act. All companies are governed by Insurance Act. Clear?
Yes, sir.
Clear, sir.
Yes, whatever is coming on the board, everything is getting recorded. As it is, you will see it on there. No change. This only you will see it again. So this recording will be helpful for you people only who are participating here. If some outsider wants to see, he will get bored.
So, still my question is there that if articles have more stricter provisions and the board decides to go for normal provisions that are given in Companies Act, then what will we have to do? What the board will have to do?
Correct. Now I will answer your question. Again, I'm writing on the board. Okay. So everybody got the question? The question says, articles have much more strict provisions than given in the act, and board wants to comply with the act